Good morning. I found an article I wanted to read. I've hit on it a couple of times, but today I'm going to do my very best to read it. This is from Georgetown Law, and it's the Center on Transnational Business and the Law. Overview of the proposed binding treaty on business and human rights from March 9th of this year, 2023. And it says this: recognizing that victims of all disasters caused by businesses should have a prompt and effective remedy in future situations. The international community has for several years been considering a comprehensive international approach to such situations involving a binding international convention on business and human rights. A draft of the convention is being negotiated and amended in order to reach a compromise between states. One of the most notorious environmental disasters ever caused by a transnational corporation was the Mark Copper mining disaster in December of 1993, when parts of a dam owned by Mark Copper Mining Corporation broke and spilled toxic waste into the Mugpog River in the Philippines. The resulting pollution posed serious health risks and destroyed critical sources of livelihood and properties of local population. Although some of the damage had been remedied and compensation provided to the victims by a mutual memorandum agreement in 1994, at least 30 plaintiffs filed suit in 2001 in the Mariduke Regional Trial Court. I'm sure I hacked that, so bear with any words that I don't say correctly. You feel free to correct me in the comments. In the Philippines, seeking additional compensation. After 21 years, in May of 2022, the court made a landmark ruling against Mark Copper Mining Corporation, awarding additional compensation in the amount of 200,000 Philippine pesos, equal to a merely 3,600 US dollars, and 100,000 Philippine pesos, equal to merely 1,800 US dollars, in quote, moral damages to the plaintiffs. Although the Mark Copper mining disaster had international dimensions, it was a domestic problem, as the Mark Copper Mining Corporation was a Philippine company, despite being managed and 40% co-owned by a Canadian company named Placer Dome. Recognizing that victims of all disasters caused by businesses should have a prompt and effective remedy in future situations, the international community has for several years been considering a comprehensive international approach to such situations involving a binding international convention on business and human rights. A draft of the convention is being negotiated and amended in order to reach a compromise between states. The current title of the draft is, quote, legally binding instrument to regulate in international human rights law the activities and transnational corporations of other business enterprises, end quote. However, in this blog, we will also refer to it as the, quote, draft of the binding treaty on business and human rights, end quote. And the draft treaty. This blog provides background, describes the content of the proposed treaty, and identifies major issues still to be resolved among states. The scope of the treaty is broad, but with respect to claims against corporations based on alleged human rights violations, the major unresolved issues are access to remedy, which include broader jurisdiction for courts, reversal of the burden of proof, removal of the Statute of Limitations for human rights abuses in violation of international law, elimination of foreign non-convenience, the scope of application, which include whether the treaty should apply only to companies of a transnational character or to all business entities, prevention of human rights violations under the treaty, and the international cooperation between states. Background and the history of the proposed binding treaty on business and human rights. Many human rights violations and environmental disasters caused by transnational companies have occurred in developing and underdeveloped countries. The United Nations Guiding Principles on Business and Human Rights of 2011, adopted by the United Nations Human Rights Council, offer a set of voluntary guidelines for states on protecting human rights, providing remedies to victims, imposing obligations upon business enterprises, and ensuring that business enterprises respect human rights. However, the UN guiding principles have not been effective ensuring that victims in underdeveloped countries can obtain adequate compensation for the human rights violations they have suffered at the hands of transnational corporations. Accordingly, in September 2013, at the United Nations Human Rights Council, or UNHCR, the Republic of Ecuador, with the support of other countries and over 90 NGOs, issued a statement calling for a legally binding international instrument to regulate the work of transnational corporations and ensure that victims of human rights abuses related to the activities of international corporations can obtain appropriate compensation. In 2014, at the UNHCR's initiative, the United Nations General Assembly established an open-ended intergovernment working group, hereinafter called OEIGWG, on transnational corporations and other business enterprises with respect to human rights under Resolution 269. This group was charged with drafting an international legally binding instrument related to international human rights, the activities of transnational corporations, and other business enterprises. The initial document containing the elements for such an instrument was published in 2017, and in proposed mechanisms for the implementation of human rights included an international court on transnational corporations and human rights. However, that proposal did not find much support, and different implementation mechanisms were subsequently proposed. 4 drafts have been developed so far for this treaty. The first draft, known as Zero Draft, was prepared in 2018 by the OEIGWG's chair rapporteur, along with a draft optional protocol. The Zero Draft did not include the creation of the International Court as a mechanism for resolving claims, but instead conferred jurisdiction upon national courts to resolve matters covered under the draft treaty. The Zero Draft also provided for the creation of a committee empowered to make comments on the understanding and implementation of the treaty by state parties, and would also provide support to member states in the compilation of information required for the implementation of the treaty. Following this draft, OEIGWG held a session in 2019 at which many delegations and organizations argued that the draft treaty's scope should be much broader and that it should include all companies, not only transnational corporations. After considering reactions from states and business entities, the chair rapporteur prepared another version called the revised draft, published in July of 2019. Based on the comments and proposals by states and organizations in the OEIGWG session held in early 2020, the chair rapporteur compiled yet another report and recommendations for the draft. A second revised draft was then published in August of 2020, alongside another document explaining the key issues and the structure of the second revised draft. A third revised draft, which is also the latest draft, also referred to as the draft treaty, was published in August of 2021. And it incorporates change from the second revised draft in definitions, scopes, access to remedy, legal liability, jurisdiction, statute of limitations, mutual legal assistance, and international judicial cooperation. The most recent meetings of the OEIGWG on transnational cooperations and other business enterprises with respect to human rights were held on 24th through the 28th of October in 2022, in which comments and proposals about the draft treaty were presented by UN countries. In addition, UN representatives, civil society organizations, national human rights institutions, intergovernmental organization, business associations, employers organizations, and international experts also participated in these meetings. But they're just now doing this. It seems like this should have been done a long time ago, but then I'm reminded that they only do things when they have to. 2, the contents of the latest draft of the binding treaty on business and human rights. The overall purpose of the proposed draft treaty is to clarify the human rights obligations of transnational business enterprises and to prevent and mitigate the occurrence of human rights abuses in the context of business activities by effective mechanisms of monitoring and enforceability. The proposed draft treaty would obligate state parties to take all appropriate legal and policy measures to ensure that business enterprises subject to their jurisdiction, including transnational corporations and other business enterprises that undertake activities of transnational character, respect all internationally recognized human rights and prevent and mitigate human rights abuses throughout their operations. And the draft treaty sets forth requirements to be fulfilled by state parties. In order to ensure its implementation, state parties would be required to amend their legislation where appropriate for it to be in accordance with the requirements and standards set by the draft treaty. This obligation was also include the establishment of adequate monitoring mechanisms to ensure effective implementation of the draft treaty. The scope of the draft treaty is very broad. It would apply to all business activities undertaken by a physical or legal person within a state, also including business activities of a transnational character. However, it would permit state parties to establish in their domestic legislation a non-discriminatory basis to differentiate how business enterprises discharge these obligations commensurate with their size, sector, operational context, or the severity of impacts on human rights. The main points of the draft treaty are 1, access to remedy for victims, 2, protection and prevention for victims, and 3, the establishment of a committee and international cooperation between states. Access to remedy. The victims would have access to remedy for damages by bringing claims to courts of state parties that have jurisdiction. The human rights abuse or omission contributing to the human rights abuse occurred and or produced effects. The state where legal and natural persons alleged to have committed such acts are domiciled. And the state where the victim is a national or where the victim is, there's that word again, domiciled? That would, let's just look it up. I don't know. This won't show up on my screen. Let me see. Domiciled. Is that it? A domiciled. The county that a person treats as their permanent home or lives in or has substantial connection to. That's what that means. And the state where the victim is a national or where the victim is located. Elmer Fedmetch. This would not preclude the exercise of additional civil jurisdiction provided for by international treaties or domestic laws, The aforementioned broader scope of jurisdiction may be controversial, as many states strongly prefer allowing corporations to be sued at their quote seat, wherever they are organized or at home. Further, courts would have jurisdiction to adjacent cases over claims against legal or natural persons not located in the territory of the forum state, in the event that no other effective forum guaranteeing a fair judicial process is available, and if there is a connection to the presence of the victim as the plaintiff, access of the business enterprises as a defendant, or substantial activity of the business enterprise as the defendant on the territory of the forum chosen. The broad jurisdictional approach would enable victims to sue business enterprises and establish jurisdiction of courts wherever it would be more convenient for the victims. And it would make it easier for victims to seek remedies against companies that it is now. Moreover, the draft treaty would oblige state parties to enact or amend laws that would allow judges to reverse the burden of proof in appropriate cases and circumstances in order to ease victims' right to access remedy. Nevertheless, the cases of circumstances under which judges can reverse the burden of proof have not yet been specified in the draft treaty. The enactment of amendment of such laws would be mandatory for state parties if they comply with their domestic constitutional law and international law. The reversal of the burden of proof is a legal concept that places the burden of proving something from the plaintiff to the defendant. For example, in an environmental case, a judge may decide to shift the burden of proof from the plaintiff to the defendant, and then the defendant would have to prove that its actions did not cause the pollution. There are international law practices where the reversal of burden of proof has been applied, such as the, I don't know how to say that, Escazú Agreement, in which to guarantee the right of access to justice in environmental matters, state parties have agreed to take measures to facilitate the production of the evidence of environmental damage by allowing the reversal of the burden of proof. The draft treaty would require state parties to adopt legislative or other measures necessary to ensure that statutory and other limitations do not apply for the commencement of legal proceedings in relation to international human rights violations that constitute the most serious crimes of concern to the international community. A statute of limitations is a legal provision that sets the maximum amount of time that a plaintiff has to initiate legal proceedings before it loses the right to do so. I think that would be a very helpful thing on the account of sometimes we don't really know what we're going to be facing after these disasters happen. And so it could be, if the statute of limitations for chemical spill is 10 years and nobody gets cancer until year 11, oops. The provision of the draft treaty that eliminates the statute of limitations provides that victims must have the right to seek remedy for international human rights violations, regardless of how much time has passed since the abuse occurred. For civil claims or human rights violations that do not constitute the most serious crimes of concern for the international community as a whole, state parties shall adopt legislation to allow a reasonable period of time for the commencement of legal proceedings in relation to human rights abuses, particularly in cases where the abuses occurred in another state or where the harm may be identifiable only after a long period of time, which we had said. The draft treaty aims to provide easier and more effective access to remedy, including the removal of doctrine from forum convenience. This doctrine is well developed in the United States, where it gives courts discretionary discretionary power to decline the exercise of its jurisdiction when it deems that another court of another jurisdiction may be more convenient to hear the case. Thanks, brain, for discretionary. One of the reasons as to why the draft treaty would eliminate this doctrine could be that some victims may have limited resources and may not be able to afford to pursue a case in a foreign court, while business entities as defendants may have better resources to litigate in multiple jurisdictions. Although the purpose of this provision is to make it easier for victims to seek remedy, it may face challenges and opposition from common law countries such as the United States. I also think it would be hard. Typically, my understanding is most of the time these cases don't get heard until multiple people have banded together. You can't just walk in, and say, hey, I think this has happened. It takes a lot. These are things that take years, and it shouldn't. I mean, honestly, if we have, I don't know, a train wreck, you'd think instantly we'd have lawyers just like they're, ambulance chasing. Maybe they're train chasing. But that doesn't seem to be the case, and I just have wonder why. Additionally, state parties would be required to ensure that the court fees and legal costs rules do not place unreasonable burdens on the victims. In other words, they shouldn't have to pay for this. And state parties would be required to provide rules for waiving certain costs in appropriate cases, which again, if a lawyer isn't going to make enough money from the settlement, there's no incentive for them to take on cases. So I would think that should be something that should be looked at as well. But what do I know? The draft treaty provides that state parties shall meet regularly in a conference of state parties to consider any matter regarding the implementation of the draft treaty and to discuss any further development needed towards fulfilling its purpose. The draft treaty would also require the establishment of the International Fund for Victims, which would provide legal and financial aid to victims in seeking access to remedies, with special consideration for additional barriers faced by vulnerable and marginalized groups. State parties would be required to contribute to this fund, either alone or jointly, or in partnership with relevant international and regional organizations and civil society. The Conference of State Parties would define and establish the functioning provisions of the fund. The draft treaty would require state parties to ensure that their domestic legislation provides for the legal liability for human rights abuses arising from the business activities of natural and legal persons. It further provides that state parties' domestic legislation should not require the establishment of criminal liability for the same acts before civil liability could be imposed. Further, state parties would be required to also ensure that their domestic legislation provides for reparations to the victims of human rights violations in accordance to the international standards. The draft treaty provides for state parties to require natural or legal persons conducting business activities, including transnational corporations, to establish and maintain financial security such as insurance bonds or other financial guarantees to cover potential claims of the compensation. Enter the insurance. The broad scope of this provision may be difficult to enforce in all state parties, as it would require every business entity operating as a state party to the treaty to have financial guarantees to cover potential claims of compensation. This would also apply to small businesses, unless state parties internationally remove this burden from small business pursuant to Article 3.2 of the proposed draft treaty. That just sounds like a really fancy way for saying the price of products is about to go up. Who's going to pay for that? The businesses, the CEOs aren't going to pull this out of their pockets. Protection and prevention for victims. According to the draft treaty, immediate family members or dependents of the direct victim may be considered victims. Really? That's nice to know. Thanks. The treaty has provided for the protection of victims by imposing obligations upon state parties to ensure that victims and their families are not subject to any unlawful interference with their human rights and fundamental freedoms, either prior to or after the commencement of proceedings against a business entity. In addition, state parties would be required to protect victims from re-victimization in the course of proceedings initiated at national courts for violations under the draft treaty. Further, state parties would be obliged to investigate all human abuses covered under the draft treaty and take action against natural or legal persons where appropriate. The best protection is prevention, and the draft treaty provides for state parties to enact proper legislation and policies to ensure that all business entities subject to their jurisdiction comply with human rights and mitigate human right abuses in their business activities and relationships. Particularly, state parties would be obliged to add a due diligence requirement upon business entities subject to the jurisdictions in the following manners: to take appropriate measures to prevent and mitigate potential human right abuses with the business entity causes or contributes to through its business activity, to monitor the effectiveness of the measure to prevent human rights abuses, to communicate regularly and in an accessible manner to affected or potentially affected people. Further, the state parties would be required to ensure that the measures of business entities subject to their jurisdiction would include publishing regular human rights, labor rights, environment, and climate impact assessments, conducting consultations with individuals or communities whose human rights can potentially be affected by business activities, and integrating human rights due diligence requirements in their contracts. According to the draft treaty, the obligations imposed by state parties upon business enterprises subject to their jurisdiction could have different requirements depending on the size, nature, sector, location, operational context, and risks associated with the business's activities. 3, the Committee on International Cooperation. To oversee the operation of the draft treaty, a committee would be established consisting of 12 experts at the time of entry into force of the treaty. And after an additional 60 ramifications, this number would be increased to 18 experts. The experts would be elected by state parties based on equitable geographical distribution and differences among legal systems. State parties would be required to submit reports to the committee on the measure they have taken to give effect to their undertakings under the draft treaty. And the committee would be authorized or required to provide concluding observations and recommendations on these reports submitted by state parties. It would also have the power to make normative recommendations on the implementation of the treaty, provide recommendations on the reports by state parties, and provide support to state parties for the compilation of such reports. This committee would also be required to provide support to the state parties in the compilation and communication of information required for the implementation of the draft treaty. Man, they make these things tongue twisters. Disputes between states parties to the treaty about the compliance with its provisions would be resolved by the International Court of Justice or arbitration in accordance with the procedures and organization mutually agreed by those states. And the draft treaty would be open for signature by all states and by regional integration organizations at United Nations headquarters in New York and would be applicable to those states only. Other concurrent developments. Concurrently, there has been some interesting developments in European Union's legislation, as the European Commission has proposed a new directive on corporate sustainability due diligence. On November 30th of 2022, the Council of the European Union adopted its negotiating position, general approach, on the Corporate Sustainability Due Diligence Directive. The purpose of the directive is to help the European Union transition more effectively towards a green economy as provided in the European Green Deal and the United Nations Sustainable Development Goals. The European Union could formally and ambitiously enter the negotiations, especially now that a European Union directive proposal on corporate sustainability due diligence is being negotiated. There's a major movement of businesses in the United Kingdom urging the United Kingdom government to develop, implement, and enforce a business, human rights, and environmental act. And Environment Act, which would mandate companies to carry out human rights and environmental due diligence across their own operations and value chains. Hence, it is reasonable to believe that the UK is going to implement legislation to further address ESG issues, including showing support for the proposed treaty. In conclusion, the third revised draft has added some clarity in comparison to its prior drafts and has created a clearer picture as to how the final version of the draft treaty is going to be like. When in 2050, the rapid global development of environmental, social, and corporate governance is widespread in developed countries' legislation, and the draft treaty needs to be a catalyzer of further development in all countries. The improvements throughout drafts of this treaty have become more sophisticated and acceptable among states. The main challenge that the draft treaty faces is a political obstacle, and its implementation is dependent on state parties. The draft treaty needs to fill regulatory gaps left by the guiding principles of the United Nations with respect to business and human rights, 2011. And countries' national legislation by setting clear and concise obligations upon countries. The draft treaty must set the basis for the harmonization of legislations of the United Nations countries in relation to business entities and transnational corporations' compliance obligations. After the meetings held on the 24th through the 28th of October of 2022, states have submitted proposals to the draft, and it is expected that the chair rapporteur will include states' proposals in a new draft, and the new rounds of meetings, discussions, and negotiations will follow. So we'll have, here's some, we'll have some updates. Here are some of the references that you see here. In a historic decision, courts award damages to the Mark Hopper survivors. We have the Canadian transnational dumps waste responsibility in Marinduque, Philippine Center. We have another United Council, an African group, the Arab group, Pakistan, Sri Lanka, Kyrgyzstan, Cuba, Nicaragua, Bolivia, Venezuela, and Peru. These countries here, just the rich fucking love these countries. They fucking love them, and yet if the rich love these countries so much, why don't they fix them? Why do they continue to abuse them? Do you know what I'm saying? I've known people that have gone as missionaries to some of these places that are listed here. Anyway, and it says a lot of other things here. I thought that was an interesting thing. I don't know any other channels that read such stuff. And so whenever I find something that sounds somewhat interesting, when we're talking about what's going on in the world and how to fix our problems, I don't know. This sounds like a legal jargon for how can we get away with more crimes and pay the minimum amount and worded in such ways that, minimal. That's what I hear. I don't hear this helping victims in any way, shape, or form. Let's start by saying businesses cannot dump. How's that? And if they're caught dumping, then they get shut down immediately. They're not allowed to go back and scrub the kitchen clean and do, turn all the silverware back around in the drawers, handles to the front, and then get a passing grade by the health inspector. If you are doing something wrong, your business is closed. End of story. It gets sold, and everyone who is in that area gets a portion of it, regardless of whether or not they were a victim and remembered to file a suit. That would stop them from doing really bad things, wouldn't it? Remember, in a controller's mind, it's easier to ask for permission or for forgiveness and love bomb the fuck out of you with money and flowers and candy and diamonds than it is to ask for permission. And that's what we have going on here. So I don't know. Not to mention, I don't trust a single fucking one of these people that is on any of these boards or organizations or enterprises or any of the draft treaties or I don't trust them. All right. They all scratch balls on checkerboard floors. So as far as I'm concerned, they're the last people I'd be asking to write up things for my human right. Okay. Bye.